Well, hello and welcome to the Prince Live. Today we are reporting live Monday from the Supreme Court of India, which itself should show how important the case is perhaps for the country as of now. So, when again the hearing will take place, let's put some crucial facts before the audience first. The state of Maharashtra and the state of Maharashtra was not represented today in the Supreme Court of India. So a notice has been served to the state of Maharashtra. Devendra Fadnavis, the new Chief Minister of Maharashtra, who took the Supreme Court today. So these two parties into form, saying that they have the majority to Governor B.S. Koshyari, and Koshyari's letter saying that you can come and form the government. These two letters were not produced before the Supreme Court. In fact, Kapil Sibal, senior advocate Kapil Sibal, who argued for the NCP incident, the Fadnavis government was called in to take charge of the state of Maharashtra. So this is what when the apex court produces these two documents, hearings go on for a bit, and then the court will decide whether at all it will pass orders on immediate floor test. However, Justice N.V. Ramana today, while passing the order, clearly stated that indeed they are considering the request for an immediate floor test. Let's also tell our viewers that, whether it be the S.R. Bomai case or the Jharkhand case or the Karnataka case or the Goa case, the Supreme Court of India has always favored, whenever there is a question of who is going to form the government, there is a confusion as to who is going to stake claim to the government, an immediate floor test. So in this case, the floor test is supposed to happen on the 30th of this month, that's November 30th. However, the parties are a little concerned that if it's November 30th, then a lot of horse trading or the buying up of MLAs, etc. would happen, which would also, tarnish the image of the state of Maharashtra. Back to the point as to how this case press conference at about 7 p.m. on November 22. Little did they know that Uddhav Thackeray would not be the chief minister on November 23, and it was indeed the Fadnavis government who was called to form the government. Their entire contention before the court was what happened between the intervening night of November 22 and November 23, wee hours of the morning, like 5:17 a.m. to 5:47 a.m. that governor called them to form government, and president also invoked Rule 12 of allocation business rules to revoke the president's rule in the state of Maharashtra. However, to point to note is the petitioners have not challenged the president's invoking Rule 12 of the allocation of business rules 1960, though it was debated a lot. The only question before the court was, did governor, act as a pawn at the behest of the ruling party BJP by calling Fadnavis government to stake claim to the government at the last moment without making the letter claiming which claimed majority public or produced it in the public domain. The print was inside the courtroom since morning, and just to tell you, Justice Ramana was indeed taken by surprise when he came to know that indeed the letter was not in the public domain and none of the petitioners had seen it. So it was only fit for the court to order for those documents to be presented. Solicitor General Tushar Mehta, who was also present in the court, he said that he's appearing for the central government, though he has no instructions from the central government in appearing before it, because he just got a notice from the petitioners of the plea. However, the court has now asked Solicitor General Tushar Mehta to ask the governor to provide the documents, because the centre is in its right to ask the governor to provide these documents to the Supreme Court. Courtroom, yes, Koshyari, the Fadnavis government procedures established by law. He also went on to argue that Ajit Pawar, who was sworn in as the Deputy Chief Minister, they presented documents before the Supreme Court which clearly stated that document and stated that he is no longer a member of the legislative party. So one of the crucial arguments before the court was, how does Ajit Pawar claim to become the deputy minister by saying that he has the support of 54 MLAs when about 41 MLAs have already signed the letter saying that he is no longer by Dr. Abhishek Manu Singhvi, basis of a document which stakes claim to it, from 7 p.m. of November 22 to 5:17 a.m. of November 23, which had steps, leave alone verification of the staking claim to majority in person. So these were some of the arguments which were put forth in the S.R. Bomai case, as we already know, which lays down the parameters of a flow test and how a court should intervene in such a matter, was also argued along with other precedents of Goa, Jharkhand, Maharashtra, as Senior Advocate Mukul Rohatgi and the former Solicitor General, who was appearing for two independent MLAs and some BJP leaders, also squarely argued that a governor's action is completely immune from judicial scrutiny or judicial review. He also stated that there's a bar of Article 361 on any of the governor's action, though he supported the view that indeed there can be a flow test in this case. So, but he also argued that there is no urgency in the case. There is no urgency for it to be heard on a Sunday. And he again and again harped on the point that, his Sunday was being hampered, and, he was being disturbed on this day. The court was being disturbed on this day. However, when there was no urgency, the parties could be given a notice of 3 to 4 days to reply to the petition, and the case could come up in the Supreme Court, since the floor test is scheduled to be held on November 30th. So that was one of the crux of the arguments that happened, and what the Supreme Court ordered. We have a lot of questions coming in from our viewers. Sufyan asks me, does this incident affect immediate state elections elsewhere in the country? No, Sufyan, it does not affect any kind of immediate state elections anywhere else in the country, because what happened in Maharashtra was that Ajit Pawar turned rebel against Sharad Pawar, a majority government. But let's not forget the fact that the entire dispute is of the magic numbers 145. It has been disputed in the court that Mr. Pawar had the support of only about 13 MLAs, since about 41 out of the 54 MLAs had already signed a letter, saying that he has been removed from the state legislature party. This case broadly is connected to the control of the state of Maharashtra, and as of now does not affect other state elections, though it's completely within a reasonable doubt that a floor test in all eventuality may happen tomorrow or by the day after, as soon as the court wraps up the hearing, peruses those two crucial documents, and passes appropriate orders. We have a question from Hari. Considering this is a major decision the Supreme Court has to take after the new Chief Justice Bobde, Hari, Chief Justice Bobde is not in the bench. We all know that Chief Justice Bobde is from Maharashtra, is from Nagpur. He's also been in the former Advocate General's capacity. So he is not there in the bench. In fact, Justice Ashok Bhushan, who is there in the bench, was a part of the bench which delivered a verdict in the Karnataka MLA's case. Justice Sanjeev Khanna was also there in the to ponder upon. So just to answer you in one sentence, perhaps. Chief Justice Bobde is not looking at setting a precedent. What the court is here looking at is that, in this case, it is very important for me to state petitioners have vehemently argued that starting from 1988, who would take claim to form the government. So I think this case is going in that direction also, where the court is only waiting to peruse all records and all documents before it passes an order for an immediate floor test, because the larger questions of law, whether the governor breached his official capacity by calling CM when he has support of only 13 MLAs out of the 54, where 41 have expelled him. These are all larger, broader questions of law, and which even Senior Advocate Manu Singhvi said that the larger questions could be considered by the bench at a later point of time. However, the need of the hour is to have the floor test, and that is something in the state of Maharashtra, as it had happened in Karnataka while this situation had arisen. From the political side also, the resort politics is going on at a rapid stage in Maharashtra at the moment, wherein reports were dropping in that some of the MLAs, some of the political leaders were being confined to resorts and hotels. So that is also something which the court would want to avoid in such a scenario. Abhishek Chakraborty asked what may be the minimum time for the floor test. The minimum time is absolutely nothing. Abhishek, if you see, even in 24 hours, a floor test can be, directed to be held to the speaker. The pro tem speaker is appointed, and thereafter the entire side. One of the cases to say how safeguards to floor test was also mentioned by the Supreme Court, as to how the house needs to be divided, how the votes need to be calculated, as to how important. Just wanted to show how important is the aspect of floor test and how immediate floor tests have been the jurisprudential history. So in this case also that something of that sort is going to happen, and minimum time is something between 24 to 48 hours, especially since today is the 25th. Today is the 24th, and the floor test is going to happen within 6 days on 30th of November. So anything, if they post it to 28th or 29th, it would defeat the purpose of the petitioners of approaching the Supreme Court to prevent any kind of horse trading of MLAs. There's a question from Anjali: what happens when a floor test is ordered? So when a floor test is ordered, what happens is that the house is divided into the two sections. The one who is taking claim to form the government, and the other is the opposition. So the one who takes claim to form the government is asked to provide his numbers first. So when the numbers are proven in the floor test, it is that when the speaker decides that whether they can form the government or not. And if they don't have the magic number of 145, then the opposition is given a chance to prove their majority. And if they can prove their majority, then it's a cakewalk for them to again stake claim to the state of Maharashtra. Let's also know that the governor can also, for his satisfaction, order a parade of the MLAs. A parade of the MLAs is essentially when the MLAs are present in individual. They are the ones who is consenting to it, despite in spite of them submitting the signatures to the governor saying that they are staking claim to form the government. So this is the protest, and of course the one who is able to prove majority takes over. In a situation when there is no clear demarcation of who is able to prove their majority in the court of law, or there is no particular distinction between who has the magic number of 145 in spite of a pre-poll or post-poll alliance, in that case a president's rule may be reimposed in the state, or elections may be ordered to be held all over again, as it has happened before also. Divya says Maharashtra governor met President Kovind today right before the hearing. Do you think that could impact the decision? Not at all, Divya. The Maharashtra governor is not a party to the case. The president is not a party to the case. The only possibility of the governor meeting the president is to discuss the constitutional obligations, or the impact of how they're conducted proceedings. And what is essential for Supreme Court is, whether at all the act of calling Fadnavis to form government was true or was correct or not, and that can only be judged when the documents relied on by the respondents is made available to the parties or the Supreme Court. So that is the only point where the court has stuck in. The court just have the name of the MLAs of government shows to plays a very crucial role in the entire case, because if that 145 magic number being put forward by Fadnavis is a complete farce and illegal and malified, because allegations of the BJP government. So that is a crucial answer to your question. We have another question coming in from Mr. Can you also talk about Ravi Rana, Sanjeev, the rest of the bench? What is the history in such cases? Cases of electoral importance for, whereas Justice Sanjeev Khanna was also is not a right that is available to the political parties, and that is one contention that he is now raising from the opposite side. So Justice Sanjeev Khanna remembered and recollected that argument and gave a smile. So in a fair word to say that apart from political leanings, etc., which we are not authorized to comment on, the bench has a fair expertise on such important matters of elections, floor test, and also about how governors are supposed to act in such scenarios, where Justice Ramana constantly reminded Mr. Sibal that the law, and also Mr. Rohatgi, that the law is well settled on this aspect of how the governor's action is not at all immune, and it is indeed susceptible to judicial review in case he has not acted in There is also a question from Mr. Akash Sethi. Can it happen that NCP supports BJP in floor test? Well, of course, that can happen, but then they have to face the party whip, and if they have to face the party whip, then all the MLAs will again be disqualified, because if they go against the party whip, I'm sure that NTP Sharad Pawar will be issuing that whip and saying that none of the MLAs who had signed that letter, the 41 MLAs, can actually go against Mr. Pawar in the floor of the house. So that is one crucial aspect of the whip that they may have to encounter. However, there has been a lot of past incidents, whether it be Uttarakhand or Karnataka, where political members of one political party has gone back on its own word and supported the opponent party. So that might happen, and in that scenario, of course, BJP will have a cakewalk in the case. But in case that does not happen, then the tables may indeed turn after the floor test is ordered immediately by the Supreme Court. So we all wait with bated breath what the Supreme Court decides after perusing these two crucial documents. Tomorrow at 10:30, and appropriate orders will also be passed. We'll be again here live with you, discussing questions and also discovering what else is going to happen in the state of Maharashtra politics. This is Debayan Roy, principal correspondent, reporting for The Print. Please subscribe to our YouTube channel for more videos, and like us, share us on Instagram, YouTube, and Twitter. Thank you.